Happy Monday! Guess what, guys? Your lunch is ready. What's going on, guys? Happy Monday. Yes. Welcome back to Real Talk Bougie. We are back for another live reaction. We're here to talk a little bit of true crime on today. And all of the things, okay? All things, and we're going to talk that real talk, and we're going to talk it bougie, okay? Guys, check your phone. Make sure you're subscribed. Make sure your notifications are set. Make sure that you have hit the thumbs up. Get your snack. Get your sandwich. I know all of you are on the job. Some of you are on the job getting a check. We'll get into it in just a minute. Hey guys, what's up? Happy Monday, guys. I was literally just live on Love Lies and Lace Fronts, and I have a cute little amount of time to handle this business with you guys. Anything else we need to talk about? Anything Nesto? We'll be back for some Nesto. I don't know if you guys want to talk some Nesto, we can, but we'll do that in the next hour or two that we get together later on this afternoon, if that's what you guys want to do. I really want to, this was really interesting to me, and I want to share this, guys, with you. Let's get into it. So someone did ask me what happened. You know, they wanted to get the update on Michael Jackson Balanos. We'd been waiting for them to come back to court and who's Michael Jackson Balanos? Michael Jackson Balanos is the guy who was accused of murdering a lady named Samantha Woll as he was out doing some due diligence work while he was preparing for some car break-ins. He was breaking into some cars. He was doing some things that he shouldn't have been doing out on the streets of Detroit. And as this was happening, as fate would have it, there was a murder that happened of this lady, and he was in the vicinity of the murder at the time. Her very strange and estranged ex-boyfriend actually happened to admit to the murder, but for some reason, Michael Jackson Balanos was on the street, and they decided, you know what, we're gonna do him. Let's do him instead. And boyfriend came back and was like, I was on medication, or I wasn't on my medication, or something's wrong with me. Can I take my confession back? And then they went ahead and got Michael Jackson Balanos hemmed up. Now, where Michael Jackson Balanos messed up is Michael Jackson Balanos is a habitual offender. He has been a thief. But just because you've been a thief most of your life doesn't automatically make you into a murderer. But this is really a case of fuck around and find out. And he was fucking around for way too long. And this is a spoiler alert. You guys might not like this. You know what I mean? I'm going to just say I don't even like the outcome of what it sounds like. But you know what I mean? We don't know how it's going to turn out and when he will get out. But the sentence does sound a little, Anyway, just to recap you on his original sentencing, let me just tell you. You're going to hear it in just a second, but just so we know, I should have had this ready. So he had 4 charges, right? And he was found guilty of lying to the police. Hold on, let me see. He was found guilty. Does anyone have a synopsis of this on here? Of course not. Of course not. He was found guilty of lying to the police. I think he was acquitted of second degree murder. He was acquitted. It was a mistrial on like a larceny, entering the domicile. And then also it was a mistrial on the first degree or aggravated murder or something. And because of some technicalities involved in the acquittal on the second degree, you're going to hear all of this because it's quite interesting. And honestly, I mean, they were kind of pissed because I guess I'm sure they were looking for a full acquittal, but you know what I'm saying? I'm not going to say it may not be as bad as how it sounded while he was sitting in court, but he could have really took a whole entire murder if in fact, he's maintained his innocence the whole entire time because of his activities. And the judge is going to say this, like, you were in the wrong place, the wrong time, doing definitely the wrong things. You lied to the police, you know what I mean? Like, whatever. And all of the things, he could have actually took this jacket. So he's actually really very lucky because we've seen people go down and really have had to live with something that they fervently claim that they did not do, right? So um let's listen to this. If you haven't seen it, it's very interesting. I know everybody's watching YSL right now, but I'll get caught up tonight on that. I couldn't even stick my pinky toe into YSL because I would probably still be watching it right now. So even though I'm not really reporting on YSL, I know we do a little itty bitty YSL talk here, but I couldn't even look at YSL today because I would have been in a chokehold. So this is a hearing. He had 4 charges. 2 ended in mistrial. 1 was acquittal and 1 was guilty. Okay. Let me see. Here we go.
On behalf of the people. Brian Brown on behalf of Mr. Jackson Balanos.
Good afternoon, Judge. Colonel Christian Morton, co-counsel on behalf of Mr. Jackson Balanos, who appears to my immediate right.
And I know for the record, Mr. Jackson Balanos is present as our own counsel, and you may be seated. So we have a motion to take care of.
We're not going to go through this whole thing just for any of you. We'll probably get to about 23 minutes and then there's some conversation, all of the things. The prosecutor's pissed, whatever. His lawyer is very good. And then we're going to pick up right here at about 58. So bear with me. We're going to go to about 22 minutes. We're going to go for about 20 minutes here. And then we're just going to go ahead and spoiler alert it right here when he stands up for his sentencing right at 57:16. Okay. That's the plan. That is the plan. I will share the link, of course. So if you want to go back and watch what falls in between, it's very interesting. It's very interesting. But I feel like for time's sake, let's do that. And then you guys can watch the rest on your own. I know nothing about YSL, and unfortunately for them, I don't intend to watch. That's okay. It's okay. I mean, everyone, look, there's so much court going on right now, past, future. One case, that expression, one monkey don't stop no show, girl. There's so many things for you to watch, so many interesting things, so many new things, so many, things getting ready to happen. Girl, YSL is not the end all be all. That's okay. All right, let's get into this.
First, and then sentencing on the charge he was found guilty of. I did review the defense's motion to dismiss based on double jeopardy grounds and the case of Yeager versus United States. And
hello, everyone. Bougie gang, my bad. I'm so rude. Who got here first? Who got here? 1, 2, 3 first. Okay. Bougie gang, gang stars, good. We're all, it's, what I'm saying? Mondays and Wednesdays are gang star days. Okay. Everybody, welcome, 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 and happy Monday. I love you guys. Good morning. Good morning. Fonny must have coached Hilton because she is not playing this morning. And you know what? I think Hilton, I don't know if she was off last week and 2 weeks. Maybe she was just absent from the courtroom. But yeah.
The defense is saying that that precludes retrial of both the felony murder charge and the
Okay, so listen, I cannot talk through this because this is all very complicated. You guys need to hear this. Michael Jackson Balanos' attorney, girl, he earned his check. Okay. He earned his check. Let's listen. Listen to the judge.
and then sentencing on the charge he was found guilty of. I did review the defense's motion to dismiss based on double jeopardy grounds and the case of Yeager versus United States. And the defense is saying that that precludes retrial of both the felony murder charge and the home invasion first degree charge. The people,
His lawyer found a Supreme Court case where someone had two charges intermingled with each other and they were acquitted of one and mistrial on another. And because of that, you couldn't have one without the other. And basically the way that it was done is supported by that case that went all the way to the Supreme Court. And baby, okay, listen to this.
although disagreeing with the findings or the rulings in Yeager and plan to appeal according to their brief, the actual findings in Yeager, the holdings in Yeager, and arguing that it's bad law, concede that the court has to follow the precedent set in Yeager in not in granting the motion to dismiss with regard to felony murder charge, if I'm paraphrasing correctly, but not as to the home invasion first degree. So I guess I'd like to have the people address that, and then I can have a response from the defense.
Certainly, Your Honor. The court has accurately indicated what our position is that as to the felony murder charge, the Yeager versus the United States opinion basically says that the jury has made an ultimate finding of fact in this particular case. They found based on the not guilty verdict.
So this is, let me cut through this. So basically, if you've been acquitted of second degree murder, but you still have a murder, you were it was a mistrial on the murder and a mistrial on the home invasion, you were acquitted of the second degree. They couldn't determine whether you entered the home or not. They're undecided. It's mistrial, right? And you were acquitted. If they found you not guilty of the home and of the second degree murder, they're not sure if you invaded the home. If you have, in theory, if they've said, you know what, not guilty on the second degree, you've de facto said there was no home invasion, because if there was a home invasion, potential robbery, which resulted in a murder, and you're saying on the second degree it didn't happen, well, and you can't make a decision whether it happened or not on the actual home invasion, you're deadlocked, then that would be a double jeopardy, basically, is what the defense table is arguing. So therefore, you can't bring back these charges because there was a case in the Supreme Court identical to this, and that's what happened. The Supreme Court said that was double jeopardy.
Verdict as to the premeditated murder and the lesser second degree murder counts in it. By finding that, they found that the defendant did not commit a malicious murder in this particular case. That finding in itself precludes a retrial on the felony murder charge, which, you know, as this court well knows, is that basically what felony murder is a malicious murder committed during the commission of a felony. So we do concede that what Yeager holds would require this court to dismiss that particular charge, the felony murder charge. We do object to that because we do intend to seek an appeal to Supreme Court and do seek, we'll be going through the state courts on our way to the U.S. Supreme Court. As to the other charge, the home invasion charge, also relying upon Yeager versus the United States, we do not believe that there is a similar or a common ultimate finding of fact between the acquittal in this particular case, the murder, and the home invasion. The standards that Yeager sets out is whether a rational jury could have grounded its verdict on any issue other than what the defendant seeks to foreclose, which being the malicious murder in this particular case. I think it is rational for a jury to believe, based on the facts that were presented at this case, the evidence that was presented during the trial, that it is rational that the defendant did go into the house, did go into Ms. Woll's house, without finding also that he was the person that committed the murder in this particular case. As the court is aware, why Mr. Balanos was in this area, why he was even in Lafayette Park at this time, was he was committing a series of opportunistic larcenies throughout the city, throughout the area. And that's what brought him to Lafayette Park. So it is rational for a jury to believe that he continued with that the seeking of opportunistic larcenies in the area by finding either before the murder or after the murder, finding the house, Ms. Woll's residence, available and open, and then taking advantage of that and went into the location seeking to do another larceny. So I think a rational, based on the facts that are presented in this case, even if the jury was to find that the defendant did not commit this murder, there is still evidence for a rational jury to believe that he did commit the home invasion.
Response?
Yes. Well, I guess since they concede the felony murder, we don't have to really address that issue. But as far as the home invasion, quoting Yeager, the issue preclusion portion of double jeopardy is a different analysis, where you don't necessarily look at the elements of the crime of which an individual seeks to have that issue precluded or that particular offense precluded. But you would look at the arguments that were addressed at trial and the evidence that was presented at trial. At trial, their theory was that Mr. Jackson Balanos went inside of this particular house to commit an assault. That was the predicate under home invasion 1, that Mr. Jackson Balanos went into this particular residence to commit an assault. The jury found that he did not commit any type of assault. He was acquitted of first-degree premeditated murder and the lesser included second-degree murder. So under their particular theory, that issue has already been addressed. So the inquiry is whether or not in the second trial, a jury can conclude, even by inference, that Mr. Jackson Balanos could be convicted of home invasion first degree without being convicted of a murder, which they cannot. Because, like I stated, the predicate for their home invasion was an assault. So how can, at a second trial, the jury will be in a position to find that Mr. Jackson Balanos committed home invasion first degree if he didn't commit any type of assault on her? So they basically want another bite at the apple, and they want to change their theory and say that, oh, okay, our new theory is that he didn't go in to commit the murder or an assault, but he peeked in there while she was present before the murder or after the murder, which no evidence substantiates that theory at all. They're just throwing things at the wall, hoping something sticks and changing their theory. They've already unsuccessfully argued their theory. And for them to get another bite at the apple, Judge, that would be against precedence. So, Judge, saying all of that, we feel that home invasion first degree was already litigated. That issue is precluded from any subsequent trial, and both home invasion first degree and felony murder needs to be precluded. And I wanted to address just their second theory. Their second theory was, even if it's not logical, because it's not, even if it's not logical, that a home invasion first degree could be recharged based upon the lack of an assault because he was acquitted on that. We could then.
Girl, let me stop y'all right here. Do you see the prosecutor, how bothered? He can't even sit still. I don't know if it's bonus time. I don't know if it's annual review time, but sir, I don't know if he's an elected official, this particular district attorney here, but the defense attorney is serving it up. And homie, just watch his body language the whole time. He is so damn bothered, which y'all messed up. Either you guys overcharged. According to the defense attorney, y'all underdelivered. You were not able to prove your case. And based on the jury's findings, basically, it's a wrap. It's a wrap on the murder charges. They were trying to send this man away for life. And based on the way they were charged, the way the jury came back, it's a wrap. It's a wrap. Okay? Just listen.
Tried to charge him with home invasion second degree. Basically, they're trying to say that, oh, her body was outside. He didn't do the assault, but he went inside of her apartment after she was already committed. After all of this blood was located inside of the apartment, somehow he went in there and what triggered the motion with no footprints near the door, no footprints in the apartment, but somehow he must have or could have went inside of this apartment after she was already murdered. And that's just preposterous. That's just another unsubstantiated theory with no evidence. On
top of the fact that the boyfriend they didn't ignore it because he actually testified. They didn't ignore it. And he got drilled on the stand during the trial. But for some reason, and I know what you're saying. They ignored it in the sense that they didn't charge him. They allowed him to recant his confession and then conveniently found the cat burglar or potential car thief in the midst who had the unfortunate circumstances of walking up on this body. And at the end of the day, they were not able to bring their case. I mean, if Michael Jackson Balanos did what they said he did, then you should have been able to prove your case. It's, you know what I'm saying? I'm going to just say it. It doesn't seem to be the hardest thing to convict a black man of something that he may or may not have done. I mean, let's just be real, right? It's 2024 and you can still potentially convict people in this country of things they did not do. So how is it that on this day, there was a jury of sound mind in the community who decided based on what you brought, Mr. Prosecutor, didn't find that your case measured up to what it needed to be measured up to bring the full conviction against this man of color, okay? Or this man, period, right? So I'm just saying, like the fact that the jury came through and was just like, no, we didn't get all of that, means you guys need to go back and handle that business and actually find or go back and talk to, I think his name was Jeffrey, go back and talk to Jeffrey, and you might need to talk to him one more time. But since they gave him immunity, who knows? Anyway, let's listen to the rest because we got about 10 more minutes on this side, and then we're gonna fast forward through some of the arguments and go straight to the sentencing. And I dropped the link if you want to watch that in full. And it's not in the description box yet, but I'll put it in the description box so you guys can check it out uninterrupted.
Evidence to support that. And they've already had their opportunity and they unsuccessfully argued that under the predicate that they asked this court for. They asked this court to instruct the jury to decide whether or not he would be guilty of home invasion first degree under an assault, not a larceny. So now they want to say that, oh, it's reasonable for a jury to decide that, oh, he was doing opportunistic larcenies throughout the city. So it's reasonable for a jury to conclude that, oh, he was still in that opportunistic mindset when he walked into the apartment. No, they didn't argue this at trial. Their theory was he went in there to do an assault. not a larceny. And we questioned that while we were preparing the jury instruction. Like, this is what you want, right? That's what they wanted. That's what they got. And they did it unsuccessfully. They don't get another chance, Judge. Thank you.
Reply?
My memory of what our theory was is that this was, we charged it as felony murder with the underlying being a larceny. So the reason for going into this house in the first place was to commit a larceny, not to go into this house thinking that he was going to assault Miss Wall if he happened to find her in there. That was, I believe, our theory. That's how we charged it. The jury is not bound by what our theories are. They're bound by what the evidence is presented. And what the evidence that has been presented, would it be rational for them, based on the evidence that was presented, for them to find a home invasion even without finding that he committed the murder? Our position is yes.
Just a quick reply. He states his memory. He didn't participate in this trial, so his memory may not be at where it should be in order to, I guess, recite what the elements were and what the jury instructions were.
I've got the instructions right
Okay.
in front of me.
Okay. All right,
I just had my law clerk print them off.
He's like, since you're gonna be standing up and trying to say what what was, you weren't here, sir. Okay, you were not here.
For me, but
Okay.
these are the ones I read during the trial. So in a way, he is correct, because under the felony murder charge, they had the crime of larceny and/or home invasion.
But he was acquitted for that.
Okay.
Okay.
But so he's correct that under the felony murder, their theory was larceny and/or home invasion. But under the home invasion, we had discussions about this before the trial began, and in the information itself, count 3 home invasion alleges that the defendant did break and enter or did enter without permission a dwelling located at Joliet Place in Detroit, and while entering, present in, or exiting from, did commit an assault. And while entering, present in, or exiting the dwelling, Samantha Woll was present, legally present therein. So the only theory under the home invasion charge in the information was committing an assault, not the theft theory. And in the jury instructions that were given to the jury on count 3, the second element was that the defendant entered, was present, that when the defendant entered, was present in, or was leaving the dwelling, he committed the offense of assault and battery. And nowhere in the instruction on home invasion first degree did we talk about larceny. And that was not in the people's information either, under the theory for home invasion first degree. So it would seem that the underlying theory of assault would also be barred, and that is not, and there was no mention of the home invasion of larceny under the home invasion, both in the information and in the elements that were given to the jury. So I believe, as Jaeger still appears to be good law at this time, the court is also precluded from retrying the home invasion first degree because it was based on the assault and battery theory, and obviously assault and battery would carry on with the ultimate crime of felony murder and the attack that happened to Miss Wall. So I believe that based on the theories presented by the people in the information and in the instructions as were agreed by the people in defense, home invasion first degree would be precluded as well. But I do want to address the Jaeger opinion. I did pore over this opinion quite thoroughly, and I do agree with the people that it is a poor decision and presumes that when a jury makes an inconsistent finding of being hung on one count but finding not guilty on the other count, that it must be that the not guilty applies to both. And after listening to this trial and listening to...
Let me say this real quick. Any of you guys watching Karen Reed? So just remember Karen Reed's trial, the lady in Boston, who they were hung on a couple of her charges, and she basically, it came back that the jury was going to go not guilty on a couple based on this Supreme Court ruling. Karen Reed would have been done. She would have been done. So I don't know if you guys heard about this or have heard about Yeager previously, but this is a situation with MJB that they actually did bring back the hung jury and make a decision on some of the other charges. On Karen, the judge was in such a hurry, and I don't know, people feel like the whole network up there in Boston was a problem. The judge didn't poll the jury, which she did ask, and the lawyers did not request it. But she did not enter in the findings of that jury. It was just like, oh, it'll just be a complete mistrial. Meanwhile, the jury has been talking, and the jury has came forward and said that the jury actually did have a verdict on some of the charges. Had they brought in some of the verdict, and some of the verdict had been the not guilty, Karen would have been done. And that's what they've been arguing. So I'm just hearing a little bit better explanation. I heard this before with Karen Reed, but I didn't hear it explained to the extent that this judge is really breaking it down, and we're understanding through MJB's lawyer and this judge. So it's quite interesting to hear this. So let's finish this up.
To all of the emphasis that was put on felony murder, and basically the people barely mentioned first degree premeditated.
Absolutely. That goes, you know what I'm saying? I appreciate you bubbling that up. Look, at the end of the day, I think that's just a general consensus that prosecuting the wrong person isn't justice, right? Just because you put someone in jail doesn't mean that the victim gets justice. So absolutely. If he's maintained his innocence, it doesn't mean that, somewhere like, we don't know. We weren't there. I would hope that he's not duping everyone, but you're going to hear what his sentence is. At the end of the day, he's still going to have some time to sit and think about some things, because this judge is not going to be overly empathetic or sympathetic to his situation, because she's going to give him a little bit of a talking to in a bit. And we're going to fast forward to that in a few minutes. But yeah, considering the fact that the boyfriend was the number one suspect, and the boyfriend confessed to the murder, and they gave that man immunity. I'm not sure what the details of his immunity are, but are you kidding me? So anyway, let's finish this up.
Murder in their openings, closings, or anywhere throughout this trial. The main focus, and I believe the prosecutor even said, the main focus of this trial is the felony murder. And there were still jurors who were voting for guilty on felony murder, and they were hung as to that count and as to the home invasion first degree. I don't believe this jury had any idea that when they found him not guilty on the premeditated first degree murder, that they were precluding a retrial on the felony murder. Inconsistencies, the jury can't be charged with knowing that the realizing the elements of second degree murder are essential for the elements of felony murder. They're not legal scholars. They're looking at this as separate types of charges. And I think that Judges Scalia and Alito were right when they were saying that under all of the prior rulings prior to Yeager, that a jeopardy continues until a hung jury is able to deliberate and return a verdict on all counts. But I am bound by Yeager, and I can't ignore precedent that's been set by the U.S. Supreme Court. And so I am going to have to dismiss as to both the felony murder and the home invasion first degree. I assume the people are going to appeal this decision and see what happens from there. We are today here though, and he was acquitted on the first degree premeditated murder. So then that leaves the count 4, lying to a peace officer. And we are here today for sentencing on that charge, for which the jury did find the defendant guilty. And have all parties had an opportunity to review the pre-sentence investigation report?
Yes, sir. Yes.
Are there any corrections, deletions, or additions to the body of?
So this part, some of it is really very interesting, but let's just get to this part just for the sake of getting to the part where you guys, I'm sure, like, because I was literally like, oh my God, what's gonna happen? Oh my God, how's this gonna turn out? So I'm gonna skip to this part right here, like right around here, and let me go to right here, but let me see.
Family, that's not justice to the community, and that's certainly
Okay,
not justice to Mr. Jackson
he's such a great speaker. I really like hearing him talk. He's good. He's really, really, really good lawyer. Okay, hold on. I'm sorry, Mr. Prosecutor. Okay. So this is his closing. This is his remarks before the judge gives her sentencing.
of an innocent man. They want you to sentence him to the maximum amount of time that's available under the guidelines. Judge, now the prosecutor speaks of innocent people can get convicted of crimes when individuals lie. They also said the resources of the police department. Now we saw through the pendency of this trial, multiple of their.
I know he did not. I know the prosecutor did not get up here talking about Michael Jackson Balanos lying. What about Jeffrey lying? So it's okay for the ex-boyfriend guy who says that he's a mental health patient. It was okay for him to lie, and that's okay. But Michael Jackson Balanos lies and he gets a full sentence. Is that what, girl?
Witnesses who've lied to the police, never charged. And what did that lead to? That led to an innocent person who was facing the trial of his life, fighting for his life for something he did not do. Something that was pretty obvious to anybody who paid attention to the trial, that Mr. Jackson Balanos was a victim of circumstances of the wrong person at the wrong place at the wrong time. That's all. Now, as far as lying to the police, he admitted he lied to the police. As we stated earlier, he didn't send the police on a wild goose chase. He didn't say, oh, I know who did it. It's George Lewis. He didn't say that. He said, that's not me in the picture. And he said that all of 20 minutes before he came clean? They didn't even get a chance to leave the room. They, in their mind, knew he was lying. He came clean and he was very honest and said, yeah, that's me. However, when he denied it at first, like I stated, they didn't give him any specifics of when this happened. They didn't say October 21st, October 22nd, you were in the area of Lafayette and wherever, or you in the area of Harbortown off of Jefferson. They never asked him pinpointed questions. They gave him a screenshot of somebody holding a bag and said, that's you. You were going into cars. They never confronted him with any type of evidence to suggest, like, oh, we saw you going into the car. And matters of fact, he introduced evidence that they didn't even have. He said, I was out there taking pictures of cars. They didn't have that information there. They didn't confront him with a picture of that Dodge Challenger with Coast Guard plates. He stated that. And after we found out in the trial, that was an honest statement that he made, that he gave to the police. Now, just like OV-19, if an individual denies culpability, surely he shouldn't go to prison for that. He's innocent until proven guilty. It has to be something more. Just like OV-19, it should be something more in order to rise to the level of sending him to prison. Just him initially denying culpability is not enough for a prison sentence. How many individuals lied to the police and they never charged? Through the pendency of my career, I've never heard, never represented an individual who's ever been charged with just simply lying to the police officer unless it's something super material, such as maybe they filed a false police report, they hid their car down the street, and then they said they got carjacked. And then the police are going out
Carly
looking for a
Russell.
carjacker, spending all these resources just to find out the person who made that report lied to them. Or in the case where they get on the stand and they commit perjury, like people did during this trial. People committed perjury during this trial. Are they going after them? No, but they want to act like they're so concerned about the truth. Their own witnesses, they knew they were lying. Are they going to charge them with perjury? Absolutely not, because it's not justice for them. It's not blind. They look at him and they want to convict him and they want to punish him for something he did not do. And then they wanted to get emotionally charged to bring up all of this stuff, his prison record. Where's that information at? What prison record? Was that in the PSI? Was that contained in the PSI? He successfully completed his probation in 2018. He's learned from his mistakes. The fact that he was down there, he stole some candy, not minimizing that. He was fighting for his life. If that doesn't change your life, if that doesn't light a bulb in your head or light a fire under you to change your life, I've had multiple conversations with Mr. Jackson Balanos. I can guarantee he won't even jaywalk going forward. He won't even forget to blow his nose after sneezing. That's how straight on the path that Mr. Jackson Balanos has to be, because he knows that when he walks out from this courtroom, they're going to be looking for anything and everything to try to charge him with anything. You didn't cross at the crosswalk. That's a ticket. Hopefully we find something on you. He knows exactly that. So he is not going to have any more run-ins at all with the legal system going forward. The probation that Michigan Department of Corrections recommends, and we recommend that also, he's going to complete that without a stain or a blemish. There's not going to be any type of violation, because he knows if he comes in on a violation, the prosecution is going to say, see, Judge, send him to prison. He's not going to give them the satisfaction. He's not going to give them the opportunity. Not just that he doesn't want to give them the satisfaction, because he feels in his heart and he knows in his heart what's the right thing to do, and he's going to act accordingly. Through these 243 days, he's had a multitude of opportunities to reflect on what he did that particular night. Now, he takes responsibility for what he did that particular night. And he knew that those bad decisions has led him in a position right now where he is handcuffed in front of this court. Picture has been posted across the world, across the universe. There's people on Mars who have seen his picture. And initially, before this trial, has associated him with being a murderer. How does that feel? How would that feel, knowing that you did not murder somebody? You just in the wrong place at the wrong time. And then the world is accusing you. They say, oh, the suspected murderer or the murderer. Some news articles call him the murderer. Some call him the alleged. Some call him suspected. But nevertheless, they associated his name, his picture, with the death of Samantha Woll. Now, we feel very bad for what happened to her. But charging him should have never happened, because that's not justice. That's not justice to the family. That's not justice to the community. And that's certainly not justice to Mr. Jackson Balanos. Just to get anybody, knowing that the evidence does not point at him. Judge, there was a recommendation from the Michigan Department of Corrections that Mr. Jackson Balanos be sentenced to probation. Judge, we're asking you to follow that recommendation. We're asking for an 18-month term of probation, because, Judge, I'm sure you've probably not had many cases or sentencing in lying to the police, because
Yo, he gave that speech, didn't he? Yo, he gave that speech.
they don't charge that. The only reason they charged Mr. Jackson Balanos was in an attempt to stain his character. So when he does take the stand, or at trial, he's a liar. He's a thief. He had to do it. Mr. Elsie, how many times did he say Mr. Jackson Balanos is a murderer? I mean, a liar. Oh, he lied 40 times. He lied 44 times. Lie number 1, lie number 2, lie number 3. Yeah, he admitted he lied. He admitted he lied. He's not a murderer, but he also came clean. He also told them the truth. He also told them what happened. Like, yes, this me, I take full responsibility. So 243 days, already incarcerated, fighting for his life, that mental anguish, the depression, the anxiety that goes with those 243 days. If he wasn't just sitting in a jail cell with his feet up, he wouldn't on vacation. Like that type of mental anguish to be charged with something that you didn't do, Judge, I think is more than enough to ensure that going forward, that Mr. Jackson Balanos will be a successful candidate, Judge. And considering the crime in his guidelines, Judge, we ask for a term of probation without the tether, because we believe that Mr. Jackson Balanos is not a flight risk. He was arrested twice. The first time he was arrested, he never tried to flee, Judge. So there's no particular reason why he would flee. And he understands if he does try to flee or violate probation, he would be throwing himself in front of the court, and he knows where he would be going if that were to happen.
Mr. Jackson Balanos, anything further you'd like to state on your own behalf?
Just that I've been before. It would be good in the community. I plan to go to school. I still have my job, so I'm working currently. Not right now, but when I'm out, yeah, I don't want to.
You had to see. So this is a difficult case. We started with some very, very serious charges. And while it seems like this is not a serious charge, when you add the habitual fourth offense to it, raises it to a maximum penalty of 15 years. And what I have to look at is not just the circumstances of the offense, but also the offender. And habitual fourth raises this up into a straddle cell, 0 to 22 months guidelines, and the 22 months would indicate prison. And although it is a straddle cell, I could choose to give him jail time or just straight up probation. But I also have to look at the number of times that the defendant lied. And I have to say, if lying was an Olympic sport, you would get the gold medal, sir, because you told lie after lie after lie throughout those interviews, interrogations, and even a few on the stand. And the number of lies does factor into this. Also, the fact that there were prior failures to comply with community supervision, both with an unarmed robbery when he was a juvenile, and also for the fleeing looting. And not only was he removed from the Haida prison sentence at the Thumb almost immediately, but was given a sentence of 18 months to 5 years and served out the entire term and never actually achieved parole because there had to have been numerous misconducts that apparently Mr. DeGrazia had looked up, but were not included in this report. But it's obvious there were numerous misconducts for him to serve out his entire time and not get parole. And then the other factor I'm looking at is nothing to do with acquitted conduct or the charges that had to be dismissed pursuant to that case, but also to admitted other crimes that he admitted to on the stand that will never get charged. The breaking and entering into those cars and taking pictures of cars to send to people to help them steal cars. That's all additional criminal activity. And apparently Mr. Jackson Balanos, at the time of this offense, had not learned his lesson from all of his prior dealings with the judicial system and the prison system, and was still engaging in theft crimes on the night that this happened. And that's what put him in this place to begin with, and ended up having him charged with the more serious crimes. So it is the sentence of this court that Mr. Jackson Balanos be sentenced to a period of incarceration of 18 months to 15 years in the Michigan Department of Corrections with 243 days credit for time served.
Did you see the attorney? He gave much at he's like, what the fuck? Like, get the fuck out of here. He gave her a fuck out of here. Ah. And I mean, absolutely, because he basically has been acquitted of the most serious charges. And he's getting 22 months to 15 years or 18 months to 15 years. But keep in mind, he's getting 240 some days credit, which, you know, look, he could possibly be getting out of there in 9 months. I mean, at the end of the day, he could be walking out of there in about 9 months, maybe free and clear. He may end up with some additional probation. Was it parole? Excuse me. Um, they're setting an example, and they're also probably giving the state some time to hurry up and file some appeals and all of the things. But this will be, I mean, this is a Supreme Court ruling. There is no way that this is not going to have to go back to the Supreme Court. You don't see state appellate court go against United States Supreme Court rulings. Michael Jackson Balanos will be like 10, 15, 20 years older before this ever gets to the Supreme Court. And that is if they decide to take the case. Because the one thing we know about the Supreme Court, they have to take your case. You can submit the case. It doesn't mean that they're going to take it. If Judge Alito or whomever the presiding was over on that case, and that case is holding, and they do not want to upset the apple cart or whatever the case might be, it stands and it's standing and it's continuing to stand. They can take it, they can threaten to take it to damn Disneyland if they want to. It doesn't matter. So just because you say, oh, I'm going to take it to the Supreme Court has to take your case. You can't just go run up in there and say, all of the things. You cannot. Okay. So let's finish this up. We have like 5 more minutes. I'm gonna let y'all go. This was just such a good. I hate that we didn't really watch this from the beginning, but we did watch some of it. So there is some coverage of this case on my channel. But this was such a good case, and this lawyer is so good. And the case was so weird. I definitely, if you're looking for a case to follow, it's the murder of Samantha Woll and Michael Jackson Balanos defending himself against the accusations of first-degree murder and the 3 other charges that he is now 3. 1 that he was found not guilty, 2 that would be precluded based on double jeopardy by a Supreme Court ruling. And he is now sitting for sentencing of lying to the police, if you can believe it. Meanwhile, Jeffrey confessed of a murder and he's home.
$8 state costs, crime victim assessment fee of $130, no probation. Court costs of $1,300, which is the amount this court has estimated it's the average cost of a case coming through this courthouse. It's my duty, sir, to advise you of the right to seek appellate review of your conviction and sentence. If you're unable to afford an attorney, one will be appointed for you. They'll be given transcripts needed to prepare your motions or an appeal. If you wish to seek an appeal, you have to sign and date your appellate rights paperwork and mail it to the clerk of this court within 42 days of today's date. Your client's already initialed the form?
Yes.
Okay, we will give him a photocopy to take with him.
And Judge, just for the record, you made a reference to my client lying on the stand. Like, that's unsubstantiated that he lied on the stand. That wasn't even alleged that Mr. Jackson Balanos lied on the stand, but this court made reference to he lying on the stand. And just for the record, Judge, he successfully completed his last probation he was on in 2018. So he demonstrated to the court that he does have what it takes to be successful on community supervision. If you're going back from 2013 when he's 19 years old, I mean, this is 11 years ago at his last probation that he didn't successfully complete it. 2018 was his most recent probation, and he successfully completed that probation, and they closed him out.
Sir, I've heard you out. He may have completed that one, but then he was out committing theft crimes the night of this event.
Okay, but
admittedly,
Okay, but
and
Judge,
he's never going to face charges on that.
okay, so that's uncharged conduct, and Judge, if they wanted to charge him on that, they could have charged him on that. But in this building, Judge, we got to be honest with ourselves. How many individuals get sentenced to prison for lying to the police, especially if they're not being charged with any type of larceny? That just doesn't
Yeah,
happen.
how many of those people are habitual fourth offenders? I'm done.
A lot
That is
of
my
them.
sentence.
A
You
lot
can
of
take it to the Court of
Oh,
Appeals.
well.
Defendants remanded to the custody of the Michigan Department of Corrections. I believe that dismissal has to be with prejudice, correct? It's pursuant to the case law.
Yes.
The prosecutor's table knows that they fucked up and they charged it in a way they're going to look. This to me, and I'm a lay, obviously I'm not a lawyer. This to me as an observer is going to send a sharp message to prosecutors. Stop overcharging people. You overcharge and you underdeliver in your presentation to convince a jury. And if the jury is aware or the jury decides to come back with some verdict versus no verdict, guess what we've all learned? And we're all slowly learning because people are watching the Karen Reed case. People watch this case. Guess what we all learned about? We all learned about Yeager. Guess what? That's what we learned. If you didn't know something from YSL, if you didn't learn about Brady in the Adnan Syed case out of Baltimore many years ago that kicked off the podcast Serial, you learned about Brady then and you hearing about Brady now. You understand what I'm saying? Like the knowledge. When would they have brought this up? They're sitting up there talking about they wanted to bring the charges back. If Michael Jackson Balanos' lawyer did not bring up Yeager in his motion to dismiss, do you think the prosecution, they were going to be happy-go-lucky trying to bring him back these charges? They weren't going to say, oh, well, damn, Your Honor, we realize that because the jury brought back half a verdict, now it's precluded because now he's got double jeopardy. So that Michael Jackson Bolanos could have got convicted of something else. They would have brought back something else and then, or brought it back and then tried to convict him. So this is very this is interesting. This is so very interesting. Anyway, they're getting ready to get up and go out, but dismissed with prejudice.
Motion of defense.
The judge is pissed. You could tell the judge is not happy about this. Whether they feel like he did it or not, I don't know if Michael Jackson Bolanos is a murderer or not, but I feel sorry for Samantha Woll's parents because I could only imagine the pain and suffering that they're going through with this this whole entire situation and the loss of their child, their auntie, sister, daughter, all of the positions and roles that this woman played in many people's lives. She was a leader at her synagogue and all of the things. I don't know. I don't know what they did. If they got the wrong guy, obviously her boyfriend confessed. I would start there. The jury did not feel like, regardless of that, excuse me, I'm trying to extricate myself of using irregardless. Regardless of the fact, the jury did not feel like you brought the case against Bolanos or there was enough reasonable doubt based on Jeffrey. Maybe. I don't know. But this was so interesting. So anyway, I put the link to this whole hearing in the description box. And all you have to do is just Google Michael Jackson Bolanos and you'll get all the videos and all of the articles and news stories and all of the things. And again, I hope and wish the best for the family of Samantha Woll because it's a tragedy. She looked like a beautiful woman. And again, she was living her life and did not deserve that ending that happened to her out in front of her house. And her neighbor that found her. And, it's just terrible. But just, he was out robbing cars and taking pictures of Dodge Challengers. I don't know that he was out there trying to go into. He was out looking at cars. They didn't see him. I don't know. There was some video of him kind of hiding in places, but he wasn't known as like a cat burglar. We don't know that he was breaking and entering into homes. His thing was more stealing cars, breaking into cars and things like that. And oftentimes, not every time, people don't necessarily deviate from their crimes of choice. Like they have a particular thing they do. And he was out doing his thing. And if he was out to commit a murder or to break into someone's house, most people who break into homes break into empty homes, right? Not a home where somebody's there and risk, all of that. So anyway,
No, we just,
they're probably telling him, look, you could be out in a couple of months. Just play it cool. Just be cool. Just be cool. Look at the family. It's Jeffrey, guys. Wall family, you need to talk to Jeffrey. You need to talk to Jeffrey. They need to reassess Jeffrey because Jeffrey is the man. Anyway, guys, I'm going to let y'all go. I got to handle some business. I'll be back a little bit later. If you guys want to talk some Nesto or something else, let me know. I'm going to look into what we talked about getting back up with. I know we talked about a couple of things yesterday. I think phone calls from prison has dropped like 2 or 3 Wade videos today. And I know that that's very much overdue. We've been talking about Wade. Let me pull this document up real quick. I have this. Hold on. We're going to talk. Maybe we'll talk about this when we come back. Hold on. This is when an inmate in Lee County was experiencing an overdose on April 7th, 2023, approximately 10:18 a.m. Due to the severity of the overdose, Wade Stephen Wilson was transported to Lee County Emergency Medical Services to Lee County Hospital. The medical records and the trip sheets are relevant to the pending trafficking, amphetamine, and conspiracy to traffic controlled substance case against Wade. Communication discussions with the medical professionals known and expected to be named within the medical records is also necessary to obtain information relevant to the investigations. These communications will be limited to the above referenced incident. So this is a brief with some very interesting information. We did read the most of the affidavit, but there were some other things in here that I found to be quite interesting that I kind of wanted to talk to you guys about, like some behind the scenes details. We haven't really done a reaction on any of the calls yet. But I'm just trying to get into understanding a little bit more about what's been going on with Mr. Wilson down there in Fort Myers. Anyway, guys, I'm gonna let y'all go. I gotta run. I will see you guys back in a few hours. Maybe I want to talk about the Kelly call that they posted, and hear about Kelly. Because I'm interested as to why she hated him so much. She was so over him. She called him about Mila, or she called Mila and talked to Mila about him, and damn it, she's sitting up there talking to him. Okay, low key wanting him back. I think, you know what I'm saying. I know she's a victim and all of that, but sis, you know what I'm saying. Like, we're not even getting into that. Sis called Mila, had plenty to say, and then sis damn on the phone with him, and then talking about all the people you cheated on. Like, a mess. So anywho, I'm gonna talk to you guys later. Hit the thumbs up for me if you're new here. Make sure to subscribe, hit the notifications, hit the thumbs up. I appreciate it so much. Okay, guys, take care. Have a good afternoon.